Cutler and Donahoe welcomes you to their booth at the Minnesota Inventors Congress's annual Inventors Expo.
Jared Clark and Alex Hallback have driven from Sioux Falls today to join the attendees at this year's Congress.
We are here to talk about patents, trademarks, and the business services Cutler and Donahoe have to offer.
Let's get started by answering some common patent questions.
What is a patent?
Good question. A patent is a set of legal rights in an invention that allow you to stop others from making, using, selling, offering for sale, or importing your invention. Patents do not protect pure ideas, but instead protect the applications of the idea that make it useful. Ask Jared for more information.
Thanks. Why should I get a patent?
With a patent, you can stop everyone else from copying the patented invention. In addition, patents can help keep competitors out of the market, generating revenue, defending against competitors' patents, and finding new means of investment. If you'd like to know more, talk to Jared at our booth.
Okay, how do you know it is patentable?
Well, according to the courts, anything under the sun that is made by man is patentable. Basically, any idea that has, or is given, a practical purpose, is an invention, and is eligible to be patented.
Ha! There must be more to it. So what if I want to patent an idea by someone else?
I'm sorry, but you can do that. There are 3 primary requirements for patentability, and those are that the invention is new, useful, and non-obvious. New simply means never done before. Useful means that the invention actually does something, has a purpose. A pet rock, for example, can hold down a stack of papers. That's its purpose. Finally, non-obvious is the reason patent attorneys exist. Non-obvious has a fuzzy description, but is basically means that someone of similar skill in the subject of the invention wouldn't think of the invention on his own. This is one standard that results in a lot of patent applications being rejected, and it's important to know how to respond to.
The non-obvious standard is a little strange to wrap my head around.
Feel free to ask Jared for more information.
All right, let's move on to my next questions. Who actually gets the patent when and if it issues?
Patents are granted only to the actual inventor or inventors. Patents are not granted to businesses. When you hear about IBM or Microsoft having a patent, that just means that one of their employees got a patent and assigned it over to the company by signing a special form. One of the first things a patent attorney will try to do when you meet with them is to determine who the inventor is on an invention. It's vital that inventorship be correct in a patent application.
I didn't know that. Thank you. Where can I enforce a patent, and how long do I have to do that?
You can enforce a patent only in the country that granted it. A United States patent only gives you rights in the United States. You can enforce the importing right of a patent by preventing your invention from being imported from other countries. Oh, and you have 20 years from the filing date of the patent to enforce it.
When should someone file for a patent?
As soon as possible, once they come up with the invention. Basically, as soon as you can describe the invention so that someone else could build it or make it, a patent should be filed to show the patent office that you were the first inventor, and make prosecution of the patent easier.
I thought I had 1 year to file for a patent.
That's true, in that you have 1 year from the date you publicly disclosed your invention to apply for a patent. If you wait too long to file, even without making it public, you may not be able to file. That is considered abandoning your invention. There are a lot of issues involving when to file an application, and even the type of application to file. Be sure to ask these questions to a patent professional to get the best answer. If Jared is available, I know he would be happy to visit with you.
Okay, thanks. Here's my final question. What does it cost to get a patent?
The cost of a patent application depends greatly on the invention, what it is, and how complex it is. If a registered patent attorney is handling your patent, expect to spend upwards of $4,000 to $5,000 for the most basic inventions. That sounds like a lot, but to draft a solid application, at least 30 to 50 hours have to be spent, mostly by the attorney preparing the application, but some with the client gathering information. It is a good idea to ask your patent attorney for an estimate before you have them begin work. Some firms, like Cutler and Donahoe, perform patent services on a graduated flat fee structure. Those types of firms will look at your invention and give you a flat fee that won't be exceeded for preparing the application. This can help you plan how much to save to pay all the expenses.
Thank you for taking the time to answer my questions. I think I have a better understanding of how patents work and how to get one. If I have any further questions, I'll call up my patent attorney and ask. Thanks again.
You're very welcome. Have a great day.